Attorney Horwich.
May it please the Court. My name is Esther Horwich, and I represent the defendant, Shea. This case raises a number of interesting issues, and the first I'm going to address is that the blank look in this case is not an adoptive admission where there was insufficient evidence that Mr. Shea had heard or understood what was said, that there was insufficient evidence that he was in a position to respond, and that even the judge had doubts as to whether this was something that someone in Mr. Shea's position would respond to.
Didn't the witness testify, though, that she thought he heard her quite forcefully?
She said that was her impression. However, if 3 conversations are going on, and what she said is she said it loud enough for him to hear. I would just suggest.
Didn't she also say that he stopped and looked at her?
He stopped and looked at her. But if I were to say, "Hey, you'd stop and look at me." But if someone else was yelling you at the same time, you might not necessarily hear what was said. So in this case, there's no evidence that he understood. Why do we know this? Because he gave her a blank look. It wasn't a silence. It wasn't a smirk. It wasn't a grin. It wasn't a sneer. It was a blank look. And blank looks, by definition, by common sense, they mean, I don't understand. There's confusion. And this court has been very wary of adoptive admissions where there's nothing showing that there is an acceptance of this admission. And I would suggest to this court that a blank look simply is not enough to show acceptance.
Now, the standard, I gather, is abuse of discretion with regard to the admission of the evidence.
Well, the judge has to find 3 prongs, the 3-prong test. And essentially, this judge abused his discretion because he used the wrong test, and we know that from the record. Essentially, he said that, and the section is in my brief, he had his doubts as to whether there was, and I quote, a question or statement, or whether the statement begs a response at this point in time. I'm not sure that it's a question. So clearly, he didn't satisfy those 3-prong tests.
Wasn't the statement, "What did you do that for?" or something to that?
That's messed up, that you did that to Diamond. Why would you do it? She was only 14. So our position is he didn't hear it, but the judge did not make a decision based upon the test. So I think it was definitely an abuse of discretion, and the only issue is whether it satisfied those 3-prong tests, because the judge, not only did he not use the right test, he also said, well, the contextual aspects of it and the degree of ambiguity will be subject to cross-examination and will go to the weight rather than the admissibility. And I would suggest that the 3-prong test has to be satisfied by the judge as the gatekeeper of the evidence. Is this reliable? He didn't use that test.
But why can't we have some confidence that the jury can sort this out? I mean, it's not a hard concept. Did the person hear it? Is it the kind of statement that would trigger a denial if it were not true? It's not rocket science. It's not something that a jury can evaluate. And there were other admissions he made. It wasn't even the only admission. It was the only adoptive admission, but not the only admission. So,
well, if the judge can't follow the test, can we naturally assume that the jury does? There is case law from this court that
but his instructions, I gather, to the jury were correct. When he instructed the jury as to it, he gave them the proper instructions.
I'll get to that. But he read verbatim from, or essentially verbatim, I'm sorry.
You're referring to transferred intent.
Yes, I am referring to transferred intent.
I think with respect to adoptive
yes,
admission,
adoptive
he gave correct
admissions.
instructions, so the jury was properly guided.
But if the judge couldn't follow the instructions, can we naturally assume that the jury did?
Where is it that the judge didn't follow it? Because of the hurt? Is it the first prong?
Well, it's in, we don't know what he found with regard to the first prong, but we know that he had his doubts as to, and he said that he had his doubts as to whether what she said was a question meriting response. And then the test that he used was that it would go to the weight rather than the admissibility. So he didn't follow it. So I would suggest that based on that, we can't naturally assume that the jury could. And this court has held that when you introduce evidence, even a curative instruction is not sufficient if the evidence shouldn't have been admitted in the first place. Now, here in this case, the court in Babbitt acknowledged that silence may mean something other than agreement. And in this case, a blank look is certainly nothing that is indicative at all of agreement. This was a situation where two men had approached him. One of them had gotten into fisticuffs for a good 5 minutes with him. The two men were continuing to argue and yell at him. Somebody 15 feet away says something. If he rivets his attention back on these men who are continuing to yell at him while this is going on, I suggest that that is not sufficient to show that this is a circumstance which would be conducive for him to say, excuse me, gentlemen, let me turn my attention to this lady 15 feet away while you who've just assaulted me and are continuing to yell at me, wait. And for those reasons, it doesn't fall into the adoptive admission. Because the judge used the wrong test, because this should never have come in, I think the issue then becomes, did it prejudice? Now, there's been evidence that Mr. Shea, it's believed, he made admissions to other people along the way. And at least one of those admissions was contested, one person saying this occurred in the car, another witness saying nothing was said in the car. But the big issue is the caliber of the admissions. The defense theory was these gang members conspired to throw Mr. Shea under the bus. He was either a hanger-on or someone that wasn't really appreciated. They didn't come to the police. The police did investigating, and then 3 days later, some of them, when they knew they were being sought after, came to the police.
The two other, Godbolt and Vaughn, who
Yes.
also were charged with the same crime, right?
They were, and I believe, I should have looked this up, and I apologize, Judge. I believe they pled out to lesser. I don't know if the prosecutor.
Well, but my point is, they
Yeah.
were charged with the
They
same
were
crime.
they were charged.
And weren't they part of the same SWAT or SWAT group?
They were definitely.
So, well, I guess my question is, is your theory that somebody was putting all three of them under the bus?
No, they weren't. They weren't tried in this case.
I know they weren't tried in this case,
The
but
theory was that Mr. Shea was the one that all these witnesses were pointing at. He's the shooter. He's the one. If we look at, there was another witness who testified various stories. He had 3 different tales of who was involved. But in this particular case, defense theory, the theory he was espousing to the jury was this gang is throwing this man under the bus. So here along comes a lady who has no gang affiliation. She's not a gang member. She's whatever the defense counsel can do to discredit these witnesses, he can't discredit her with that same gang title. And that's why this evidence is not cumulative, because it carries a different weight. Furthermore, when the prosecutor in his closing argument, when he discussed all these admissions, he was giving the gang members' weight the same weight that he gave her. So in essence, he used her credibility to bolster what the gang members were saying, that Mr. Shea was making admissions. So there was prejudice in this particular case.
If I can turn you to the mental note issue with regard to voir dire, how can you show prejudice? I know you may be able to show it's not a appropriate practice, but how can you show that your client was affirmatively prejudiced? I gather that a fair number of jurors did say, I had made mental notes and I want to bring to your attention my affirmative answers to certain questions.
Well,
so how can we say that that had any consequence on the verdict here? Well,
clearly a witness midway through the trial comes forward and he says, I know this officer, I stumbled on his name. Now, what does stumbling on a name mean? He heard the name, but it didn't click, or he didn't remember to say something to the court.
That happens all the time. All the time.
It does, but in this particular case, had he said it at the beginning of trial, counsel could have used his peremptories.
But my point is that even when the court officer is writing down the number, it is hardly an unusual circumstance that somewhere in the trial a witness says, oh, I now remember, I know that person, or I've got some connection to that person.
And Justice Botsford, that does happen. However, if it had happened at the beginning of trial, counsel could have said, I want to use my peremptories. And in this particular case, asking jurors to remember 21 questions and 50 names And this juror was questioned, and the judge called him up, and the juror came forward, and he says, well, you have a mental note, what is it? The juror told about one of the items, and then the judge went on. It wasn't a thorough, do you have anything else, do you have anything else, do you have anything else? The juror might have remembered, might not have remembered, but asking them to remember 21 items and 50 names, it's the wrong procedure.
But when the juror came forward, and I've not read the sidebar, which I assume there was with the juror, did the juror say, I recognize the name when you first mentioned it, and I just forgot to tell you, or I thought, from the briefs at least, the juror had said, it's a pretty common name, I just wasn't focused, I hadn't seen him in 8 years, and then I saw him and remembered him, which means that he probably wouldn't have,
Right.
means that it wasn't this practice which caused him not to bring it to the court's attention.
I don't believe it's that clear. I have the cite to the transcript in my brief, but I don't believe that it was that clear. I don't think it was, I saw him and then I remembered him. It was, I stumbled over his name, which was a kind of vague thing, which would be somewhat indicative of occurring beforehand, stumbling over a name, as opposed to, I saw him standing there, and as soon as he testified, I remembered, I know this man. So in this case, it deprived, the defense counsel obviously wanted this man off the jury, and the judge questioned him and said, well, there's no cause for it. But that's why we have peremptories. And had the man had this occurred prior to trial, he could have used his peremptories. Now, counsel was not thrilled with this procedure and made his dissatisfaction known. And now, if this man hadn't come forward, we wouldn't have any basis for doing anything, but the fact is he did come forward.
But I gather, apart from apparent dissatisfaction, the defense attorney never said, I object.
No, he was inartful in that respect, Judge. He just
Inartful or just didn't choose to object? I mean, I assume he said objection other times during the course of the case, so it's not as if he didn't know the language.
He didn't say the magic word, Judge. On the other hand, I give trial counsel some leeway that if you're trying a case, I question whether saying I object to the procedure would be anything more than the ancient, I'll take an exception to that. He should have said it, would have been better if he said it, but he didn't. The transferred intent instruction is one that is very disconcerting. Counsel objected to it on the grounds that it shouldn't have been given. And I wrote a brief saying the wording was bad. In rereading it, preparing for this, I'm realizing that perhaps under Section 33E, this court might want to consider it for trial counsel's original objections, but for the purpose of the argument, I'm going to deal with the language. This language was taken from the case of Commonwealth versus Pitts. And the instruction started off, if I point a gun at one of my court officers out there intending to kill him or her, and when I point that gun and have in mind the intent to kill him, and by mistake I miss and hit the court reporter or the clerk. And it doesn't get better from that.
Not a great example, but is it a wrong example?
I would suggest Pitts should be overruled. I did go back, I did look at the briefs in Pitts. Counsel never objected to the language of Pitts. He just said you shouldn't give a transferred intent instruction here, but never objected to the language. It was never briefed. It was never argued.
I can't remember the year of Pitts, but what was the year?
It wasn't that old. I think it was 89. It wasn't that old a case. I can look it up.
Well, in any event, my point is only this. It may not have been objected to, but the fact that the court actually quoted it verbatim in the decision might suggest that they thought it was okay.
I would think that would certainly be it. However, I would ask this court to overrule it because it isn't okay. It's extraordinarily flawed for a number of reasons.
It puts the jurors in fear that somebody, is that what you?
Well, if you have someone talking about shooting around the courtroom, I would think that it is essentially, and certainly unintentionally, but it is essentially saying, put yourself in the place of the victim. You could be sitting here and get shot. If I miss the court reporter, if I miss, we have no court reporter, but if I miss the clerk, I might shoot you in the jury box. There's nothing different. It's essentially a put yourself in the place of the victim instruction. And coming from the judge,
How would you, if one wants to illustrate the concept of transferred intent, how do you think it should be done?
Well, I didn't include the jury instructions in my appendix. The prosecutor did, and there are two different jury instructions. One from another case, essentially verbatim, and one that the defense counsel wrote. And either one of those are good. Now, the one the prosecutor added in trial didn't involve any shooting. It talked about if you hit someone, because that was the other problem with this. You are saying, here's a gun. Look, this defendant had a gun. The prosecutor at least used the word hit in the request for jury instructions, which was better. I would obviously prefer the defense version of the jury instruction if you had to use such a jury instruction, or you could just simply say, you could just essentially sum up this in a sentence or two without giving examples. And I do that in my brief of this is all you need to say. But in any event, you've got my version in the brief, you've got defense counsel's, you've got the prosecutor's version. None of those involve shooting people in the courtroom.
If I could just ask you, because you referred to it before, why is it that you think that under 33E that the instruction should not have been given?
Well, I didn't raise this in my brief. What trial counsel did, and this is the only reason I'm mentioning it because I was rereading everything, they say it shouldn't be given because there is no evidence that he intended to shoot a specific person. And in the transcript, in the defense judge's argument, the judge gives his reasons for it, which is why I didn't brief it. But because this is a 33E, I would just call the court's attention to it. I didn't brief it, but trial counsel did raise it.
Okay, but why would that be true as a matter of law? I mean, if I fire 6 shots intending to kill somebody out there, do I need to identify a particular person who I intend to kill to have the benefit of the transferred intent instruction?
Absolutely not, but it might be murder 2, a murder 2 versus a murder 1.
If you intend to hit a house which you believe to be a house of another gang, intending to kill a member of another gang, and instead you strike a 14-year-old girl who happened to be there, why would that not generate a transferred intent instruction?
Well, that's the other problem with this instruction, because it says if I have an intent to shoot one person and I accidentally hit and injure another, I'm liable for murder.
Well, but we're
there's
talking
a
about
lot
a murder.
of
Yeah,
We're talking about a dead person here, someone who did get hit and was killed.
I mean, I didn't brief this issue.
Their testimony, though, about her being pulled in front of the car.
Exactly, and that's the argument the judge used. All I'm doing is saying to this court, defense counsel raised it. This court may wish to consider it. I didn't brief it, and for the reasons essentially that the judge handled there. But I'm just calling this court's attention to it. The other problem with this instruction is what I read about murder. If I shoot someone and I accidentally hit someone and injure them, I'm guilty. It's murder. Well, that's not the law. You do have to have an intent to do more than that. The instruction itself is confusing. It's settled law that if one intends to do a wrongful and unlawful act which is punishable because it's wrong in and of itself, and in doing so he inflicts an unforeseen injury, he's criminally liable for that injury. So if the jury thought, hey, this guy's just shooting randomly, and not at the house, but if he's just shooting randomly, oh, he's guilty of that, of killing the person. And that's not the right instruction. And if the jury relied upon this instruction of transferred intent, which is the only way they would have convicted him, because there's no evidence that he went out there to shoot this 14-year-old girl who just happened to be there because she ran away from home. This is the critical instruction of the case, and it's wrong. So I would ask this court to overrule the language of Pitts, and particularly in this case where we do have a gun, and this court should definitely overrule it and adopt as acceptable, preferably it's either the court's own language, the language the defense counsel suggests, the language that the prosecutor suggested at trial, but something other than the Pitts language. Now, another issue was the limitation on cross-examination. Essentially, Arnold, the key witness, the witness who said, I was sitting in the car, I saw Mr. Shea lean out of the car. I saw what appeared to be on his a gun in his lap. Tells another witness, oh, I didn't see anything. And counsel wanted to ask him about that. And counsel wasn't allowed.
Thank you.
Thank you very much.
Good morning. May it please the court, I'm Jane Montori, an assistant district attorney in Hampden County representing the Commonwealth in this case. And unless the court directs me otherwise, I will address the issues in the order in which defense counsel did. I'll start with the adoptive admission. In this case, the judge applied the correct foundation requirements and correctly admitted the testimony of Leah Johnson regarding her statement, her accusation actually, of the defendant and his response.
So if the, when you say applied the right foundational things, if the judge says, I'm not so sure about this, but in substance, I'm going to let the jury decide.
Well,
do you think that's a fair characterization of what he said, or you don't?
I don't, Your Honor.
Okay.
Both parties in this case filed motions in limine on this issue and set forth what the foundation requirements are. So he was well aware of those. He held a voir dire of Leah Johnson prior to her testimony before the jury. And the prosecutor elicited the fact that the defendant heard and understood her statements, that he had an opportunity to respond to them, and that he was would be expected to respond when someone accuses you of killing a 14-year-old girl. She used the victim's name, so there's no question that he knew what she was talking about. And her description of his response also, it did include, he gave me a blank stare, but she also said he didn't say anything. And this court, as recently as a week ago, has held that silence can be as an adoptive admission. It can show acceptance, and that's what occurred in this case. The court a week ago, although you found that it was not an adoptive admission in Jenkins, set out the standard in that case, and that silence can be acceptance, and it was acceptance in this case. Miss Johnson was standing about 15 feet away from the defendant.
But he's engaged in an altercation at the time, right?
He was still arguing with someone, as she described it. But if you read her description, it sounds like he stopped and he looked at her when she said this to him. She was clear that he heard her and he understood what she said. And he chose to say nothing. And it's certainly a statement that one would expect a response to in these circumstances. This was a very short time after the shooting. And I would suggest that the standard of review, if this court were to find that its admission was an abuse of discretion, is a substantial likelihood of a miscarriage of justice.
I know you say that, but as I understand it, there was a motion, as you said, both sides had motions in limine. There was a voir dire. The judge said what he was going to do, and didn't the defendant object?
Not at that time.
Not at the end of the voir dire?
No. And in fact, when she testified before the jury on page 119 of volume 2, she recounts her words and then says, and the defendant said nothing, or the defendant didn't say anything. And at that point, the defendant did not object, did not move to strike that. It was only after more questions laying the foundation when the prosecutor asked, and what did the defendant do, that the defendant then objected. But at that point, she had already said what he did. The defendant did object at that point, and the objection was overruled.
But I guess I go back, I know I should know this, but if you have a motion in limine saying don't allow this in, and then there's a voir dire hearing, and the judge says, in substance, I'm denying your motion and I'm granting the Commonwealth because I'm going to let it in, and this is why, whatever he said. Isn't that enough?
It's my understanding with the case law that motions in limine don't preserve the issue. But even if the issue were preserved in this case, this adoptive admission was cumulative of the defendant's many other incriminating statements.
What do you say on that point? What do you say to Ms. Horwich's point that maybe it wasn't because the other, yes, he certainly told Morales and somebody else,
Fowler,
that he had done, he confessed in substance, but they're part of the same group, and she's not.
Well, that was before the jury. But, I mean, it wasn't just one statement to another gang member. By my count, it was about 6. When he returned the gun to Morales, he said, I just did the hit on Bristol. He told Fowler that he went riding through the other side, which meant he went into the other gang's territory. He then, in the car with Fowler, when they're approaching 338 Wilbraham Road, where this incident occurred, said, that's the place I just hit up. And then he went on to explain how he did it. He said, I stuck my hand out the window and shot, and I don't know if I hit anybody. It might have been one of those Bristol Street kids. And that's the exact description that Leah Johnson and Taisha Burke gave of the shooting. They were with the victim on the porch of 338 Wilbraham Road. So their testimony corroborated the defendant's statement to Fowler about how he committed this murder. And then somebody asked him later, did you feel bad about killing the girl? And he said yes. And then he said that he didn't mean for it to happen. The dude just pulled the girl in front of him when I fired. So in the overall scheme of the defendant's statements, really the defendant's silence in the face of what Ms. Johnson accused him of was not of great weight, particularly because the defendant did argue in closing that he wasn't able to respond because he was involved in this altercation and all the things that sister counsel just argued to this court were before the jury in closing argument. And there was that instruction that was given, and it was the instruction that was requested by the defendant. And the judge instructed, as the defendant requested, that the Commonwealth is suggesting that the defendant's silence was evasive or ambiguous. I would suggest the defendant in that portion of the instruction got more than which he was entitled to, because the Commonwealth wasn't suggesting that it was evasive or ambiguous. It was suggesting that this is just another admission by the defendant that he was the shooter.
If I could turn to another area and not directly related, what evidence is there of intent to kill apart from his conduct? Was there any statements made that he wished to kill a member of the Bristol group?
There was evidence of the rivalry between the defendant, Godbolt, who was the driver of the car, were members of what was known as the SWAT team. Alexander Vaughn, who was the front seat passenger, was a member of the Eastern Avenue gang, but the SWAT team was affiliated with Eastern Avenue, and there was plenty of evidence from Fowler and other witnesses regarding that. There was also evidence from people like Paul Fowler, from the police, that the Bristol Street gang, which was known to hang out at 338 Wilbraham Road, which was right across from Bristol Street, was a rival gang member. There had been violent incidents between the two gangs. So this was clearly a gang-related shooting. There was some evidence that this might have been the defendant's sort of initiation into the group, although that evidence wasn't clear. It was clear that this was a gang-related incident.
Okay, but apart from that, was there any evidence of intent to kill as opposed to intent to frighten, injure, commit grievous bodily injury?
He carried a weapon, a large weapon, .40 caliber Glock. There were a number of people on the porch, and the jury went on a view. That porch was not far from the street. And I think that cases of this court, such as Santana, have shown that firing into a crowd, I'm not sure if that case is exactly on point, but firing into a crowd, especially a crowd where there's a rival gang, indicates intent to kill. Or one can infer carrying a deadly weapon and firing it into a crowd at fairly close range, actually, shows intent to kill. If the court has no other questions on the adoptive admission issue, I would move on to the juror issues. The defendant cannot show prejudice from the make a mental note procedure that the judge used in this case. He started out wanting to do that because he was going to ask the racial bias questions during the general voir dire questioning. And he thought that people might be more willing to, people would be less willing to raise their hand to that sort of question. What actually eventually did happen was he asked the general questions of the voir dire. There was a question about racial or ethnic bias that was asked during those questions, and it's set out in the Commonwealth's brief. And he said for the jurors to make a mental note. Then he called each juror up individually to ask them if they had answered yes to any of his questions, and the majority did. And then he asked 2 questions that were specifically directed at racial bias. So there is absolutely no prejudice in the way that the judge conducted this. I would suggest that it's just as likely that a juror may have forgotten that he or she raised their hand as that they forget that they made a mental note.
Of course, the only difference is that if you do raise your hand and the court officer says juror 6.3, the defense counsel has an opportunity to make a note of that.
Right. And some judges do that, but I've also been in trials where judges don't do that.
This mental note idea is one that occurs and
well, no,
to
just
a degree
when
of frequency?
Jurors raise their hand, somebody may count but not call out the numbers of the jurors whose hands are raised. So there seems to be a wide variety of ways to get jurors to answer questions. And as for juror number 72, his language isn't clear, but I think it's fairly clear from the record that he didn't recognize Sergeant Crane until he saw him testify. And then afterwards, he brought it to the judge's attention. The judge conducted a thorough colloquy with the juror who indicated that he hadn't seen him for 8 years, that he would not, his prior knowledge of the witness would not affect his determination of his credibility. And the juror then volunteered, before the judge could ask the question, that he could remain fair and impartial. So I don't think that there's been any showing that this in any way prejudiced the defendant when the judge has discretion and is the arbiter of credibility. The transferred intent instruction is the one that was given in Pitts. This court in Fisher, I believe, approved the use of examples.
But there is putting the example piece aside, it does create some confusion, wouldn't you agree, when you are talking about if I intend to shoot X and I miss and shoot, my example, I'm trying to emphasize the shoot part as opposed to intend to kill, because there's obviously a difference. So, do you think that's a problem?
No, when you view the instruction in its entirety, especially with the first-degree murder instruction, which stressed that in order to find murder committed with deliberate premeditation, the Commonwealth had to prove that the defendant had the intent to kill. But the intent to kill was also used in the transferred intent instruction. So I believe that it may be a difficult concept for some jurors to understand, so that the example is helpful. But it's not as though intent to shoot was used throughout the instruction. It was interspersed with intent to kill, and I think once...
He started with intent to kill, and he finished with intent to kill.
I think once the instruction, especially when viewed with the deliberate premeditation instruction, is viewed in its entirety, then that there can't be any substantial likelihood of a miscarriage of justice in this case. And there certainly was a basis for giving a transferred intent instruction on the defendant's statement alone, that he, intended to shoot one of the Bristol Street boys, and the dude pulled the girl in front of him. So that alone gave a basis, but I think it was clear to the jury that this defendant did not intend to kill this 14-year-old child, that he intended to kill, or at least intended to kill one of the Bristol Street gang members, and that, but the instruction made clear that he should be liable for this death nonetheless. And then if the court has any questions on the verdict slip issue, where the...
I take it the case was only submitted to the jury on
Yes.
premeditated murder, so there could be really no confusion.
No confusion at all. They were instructed repeatedly that they had to be unanimous. And the verdict slip, what was affirmed in open court, which is what controls, was first-degree murder. And that's what was checked on the verdict slip, so there was no inconsistency. It was just that the jurors didn't go the next step to check the deliberate premeditation box. But in this case, because that was the only theory submitted, there was no error. And unless the court has any further questions, I would rest on my brief and ask that this court not exercise its power under 33E. This was a case, a senseless killing of a 14-year-old girl, and her mother's impact statement I will never forget. It's in the transcript. She said that when this child was born, she wasn't sure what she would name her, but when she saw her, she was bright and shining, and she called her Diamond. And this defendant took Diamond's life at 14 years old, and I would ask the court to affirm the conviction.
Thank you.
Thank you.